Okay, let's leave the topic of special category notaries and return our discussion to the notary oath and bond, both of which are required by every notary in California. First, let me just take a moment to remind you that your commission commencement date does not allow you to begin notarizing until you filed both your oath and bond with the county clerk's office within your place of business, and you would have indicated that on your notary application. Again, this must be completed in 30 days or less, or your commission will be invalidated, and there are absolutely no exceptions. Now, if the county clerk's office for your county is inconveniently located, California notary law allows you to take and subscribe the oath in front of another notary public. The specific requirements is that the notary must administer the oath in the county where the oath and bond will be filed, and you must send that oath and bond to the county clerk by certified mail. Well, let's consider a best practices tip, which means that although it's not a requirement, the practice is highly recommended. In this case, remember that you have up to 30 days to file the oath and bond, which includes the mailing and processing. This best practices tip suggests that in order to avoid mailing or other processing delays, you really should consider personally taking these directly to the county clerk's office. If you do take the time to go in person to the county clerk's office to file your oath and bond, it will be done on the same day. We talked a little bit about the addresses you'll be listing on your application, and in particular, that your business address must be in the county where you'll file your oath and bond. There are some other addresses that we need to mention, and these are the residence address and the mailing address, which could be the same, but not necessarily. First, let's make it clear that any changes to any of your addresses for any reason must be reported to the Secretary of State in writing by certified mail within 30 days, and willful failure to comply can subject you to a fine of $500 and an infraction. If you submitted your application to the Secretary of State with either a business address for residence, or mailing address that's changed anytime during the 4-year term, including a change in your job if that was used as your business address, just send the Secretary of State notification by certified mail and do it within 30 days. That's simple, and that's it. One of the questions I get most often during a live class is how to determine whether or not a place of business is the business address. For example, suppose a notary may be applying for a commission on behalf of his or her private entity employer. In other words, the employee notary doesn't fall into one of the special category employees that we talked about before, state, city, county government, or federal civil employees. Let's say that Notary Jane has a job with Sam the attorney, and Sam wants Jane to obtain a notary commission in order to notarize for the law office during working hours. Now, let's say that Jane decides that she'll also use her notary commission to provide notary services as a mobile notary during her own time and after working hours and on the weekends. As it turns out, Sam the attorney only occasionally needs notary work, but Notary Jane has already lined up many clients to provide services outside of her normal working environment. Now, to complicate matters just a bit more, and to make the story more relevant to a business address, it turns out that Notary Jane lives in Los Angeles County, but works for Sam the attorney in Orange County. She's preparing to complete the notary application and doesn't know what to put for her business address. Well, had Jane elected to keep her notary services limited to her place of employment, or, in fact, knew that any notarial services outside of her place of employment would be very sporadic, she would have obviously listed her employer's business name and address. But in this case, Notary Jane knows that she'll be doing most of her notary work on her own time. In this case, Notary Jane will be listing her place of residence as her primary place of business, since she'll be receiving most of her notarial requests from her home by fax, email, or phone, for example. On the application, she should list her business name as either self or self-employed, or with any other business name that she's filed with the county, such as Notary Jane's Mobile Notary Services. Look, there are a lot of examples we could use, but the point is that Jane owns her commission regardless of who paid for it, and is permitted to notarize outside of business hours so long as her employer doesn't fall into one of the special categories we spoke about previously. This means that she could start her own notary business and could list that business as her business name and address. Otherwise, she'll name her employer's business name and address. But remember that if her employment is terminated at any time within the next 4 years, she's obligated to notify the Secretary of State. If after this example, you're still not sure what to put on the application for your business address, you may always use the address where you will be receiving your mail related to the Notary Public Commission as your business address. Now, your residence address must obviously be in California, since you must be a California resident to be a notary public, assuming that you're not a notary assigned to a military or naval base. There'll be specific instructions with your notary application, which is going to note that you're not permitted to use a P.O. box or private commercial mailbox as a residence address or business address. The Secretary of State simply needs to know where you live. Now, the mailing address on the application may be a P.O. box or private commercial mailbox. And who knows, you might decide to obtain a P.O. box specifically to list as your mailing address before completing that notary application. Once again, let me remind you that if your address is changed within the 4 years, or your place of business changes, or you've become self-employed for notary purposes, or you move out of the place of residence, you must notify the Secretary of State by certified mail within 30 days or risk a $500 fine and possible willful failure to comply. Use a letter, or you can complete the change of address form, which you can find on the Secretary of State's website for your convenience. It's the same website that we talked about in previous videos. In addition to the new address, your notification to the Secretary of State should include the name of the notary public exactly as it appears on your commission, the commission number, and whether the address being changed is a business, residence, or mailing address. If the change is to a business address, the notification should state the name of the business that's located at the new address, at least if that's where the notary public will be performing a majority of the notarial services. Or the notary needs to simply note that they'll be self-employed. By the way, in case you're wondering, there's no limit to submit an address change to the Secretary of State. If you change your place of business to another county, remember that the Notary Commission allows you to provide notary services anywhere in California, so you'll not be required to file a new oath and bond in the new county, although you will, of course, have notified the Secretary of State. However, if you want to obtain a new notary seal that names that new county, then of course you will need to file a new oath and bond in that new county. So, if you want to do that, if it's important to you that your notary seal accurately reflects your new county of business, then you may file a new oath and bond or file a copy of the original bond. You will, of course, need to obtain the new notary seal within 30 days. Now, once you receive the new seal, be sure to destroy the old one so it can't be lost or stolen and illegally used by someone else. What about name changes? Are you getting married soon? Well, anytime in the next 4 years? You'll need to notify the Secretary of State of the change once again in 30 days using either a letter that you write up or a name change form, which you can download from the Secretary of State's website. As with the address notification, there's no fee for the change, but since the name on the commission will be changing, you'll receive an amended commission from the Secretary of State with the new name, and then you will need to file a new oath of office and an amendment to the bond with the county clerk of the county which is the principal county of business. Well, that was a lot of information in one sentence, so let me list the important points. First, notify the Secretary of State within 30 days. Second, when you receive the amended commission with your new name, you'll need to obtain an amended bond with the new name from the bond surety company and file it along with a new oath with the county clerk's office within 30 days. Even though your commission number and commission dates will not change, you'll still need to obtain a new notary seal reflecting your new name. That makes sense, of course. Once you receive your amended commission, and the commission will be an amended commission, not a new commission, your previous commission is no longer valid. So don't continue using the old notary seal with your previously commissioned name. You're going to need to file your amended oath and bond and obtain a new notary seal with that new name. And how many days will you have to do that? Of course, 30 days. Okay, we're going to talk a little bit about the requirements for a notary if he or she receives a written request from the Secretary of State. Quite often this kind of a request is going to surround an investigation process that's going to use the information you obtained and recorded in your notary journal, and the Secretary of State may have a need for this information in a very timely basis. Whenever you receive a request from the California Secretary of State, you will have 30 calendar days to respond to their written request unless they request you respond sooner. That request will come by certified mail, so you'll have easy access to the expected date of return. But, of course, the best practice is to respond as soon as possible and just not wait for the 30 days to expire. On occasion, the Secretary of State may submit a written request for you to provide certified copies of the Notary Journal or a portion of the Notary Journal. That letter is going to indicate the time you have to respond by with those copies, and it may be much less than the 30 days. The point is, the rule of thumb is that you must respond to the Secretary of State within 30 calendar days or within the time specified by them in their letter. We spoke a little earlier about special employees and alluded just a few minutes ago to employees of other types of private businesses, noting some very important differences between the two. By now you'll remember that employees who work for the state, city, or county agency, public school system, or federal civil services, and obtained their commissions specifically for the purposes of their employer, are not permitted to notarize documents outside of their working hours or for anyone other than their employer. Any fees that are charged must also be returned back to the employer, and of course, notaries specifically providing services on a military base on behalf of the military may not charge a fee. Once again, I'm referring to these employees as special category notary employees, since these special regulations apply only to them. Most notaries who are also employees work for a private employer, and the rules are different. When an employee is requested by a private employer to become commissioned, that employer and employee may come to an agreement about who pays the fees for the commissioning, who pays the costs for the necessary notary supplies like journals, notary seals, and the bond, and so on. In addition, the employer and employee may reach an agreement as to whether or not reimbursement of any notary fees charged for notary services during the course of employment is to be made. Some private employers will allow the notary to keep all of the fees or just keep part of the fee, but this is arranged by mutual agreement. Remember, no such agreement can be made between the public sector notary employees and employers. Assuming that the employer pays for the bond and associated costs to become a notary, the private employer may limit the employer's notary services solely to the place of business during working hours, but that's where the employer's control stops. In other words, the employee notary of a private business owns his or her commission, regardless of who paid for it, and that employee may choose at his or her own discretion to provide notary services outside of regular working hours. Sometimes the employer may not know about notary laws, and they may ask the notary to do something which is illegal for a notary in California to do. Let me give you an example. We haven't really discussed proper notary procedure yet, but you'll soon find out that notary law requires that the document signer must be present before the notary at the time of notarization, that the identification document must be presented to the notary even if there's personal knowledge, and that the Notary Act must be completed in full during the notary process. We will talk much more about that a little bit, but some employers might think it's okay to sign a document and just give it to the notary to notarize later, later on in the day when the signer's out of the office, at a more convenient time. That is illegal. Or perhaps the employer doesn't want to hand over a driver's license to the employee and simply expects the notary to take his word that he has acceptable identification. This is also illegal. You get the idea. The notary needs to know before such a circumstance arises that, regardless of the employer's request, the notary is obligated to follow California law, and deviating from the law for the sake of the employer can put the notary personally at serious risk for both criminal and civil prosecution. It is the notary's responsibility to know and follow California notary law, regardless of the demands of the employer. Anyone, including an employer, who knowingly pressures a notary to violate California notary law is themselves guilty of a misdemeanor. Know the law and where to find excerpts of the law if you need to make the employer aware that a particular request is illegal. If an employer continues to pressure, consider pointing him or her to California Code Section 8225. Well, that's the end of Chapter 1. And Chapter 2 is going to start off with notarial acts and procedures. And we're going to learn how to actually perform these notary services. See you soon.